Excellent. One moment. We are live.
Thank you. Hello, everyone. I'm Claire McCall. I'm the chair of the Moot Court Honors Program this year, and it's an honor to be here with you all today. I will also be serving as the bailiff for today's round. First off, I'd like to thank everyone who's watching from home and to all of our competitors for making this year such an amazing intramural competition. We enjoyed hearing all of you argue. I'd also like to thank our distinguished panel of judges and introduce them. So we have Judge Paul Watford from the Ninth Circuit joining us, along with Sabrina McKenna, Justice Sabrina McKenna of the Hawaii State Supreme Court, and Justice Linda Bell of the Nevada State Supreme Court. Whenever the Chief Justice is ready, we are ready to begin the round, and I will call the case.
All right, is counsel ready to proceed?
Then I will go ahead and call the case. All rise. Oyez, oyez, oyez. California Court of Appeal is now in session. Chief Justice Bell presiding, along with Associate Justices McKenna and Watford. All persons having business before this honorable court are admonished to draw near and give their attention, for they shall be heard. God save the United States of America and this honorable court. The first case for argument today is Jordan Manzi versus Ray Henson for appellant and Donald Bullock for respondent. You may be seated.
All right, and counsel, whenever you are ready.
Good afternoon, Chief Justice Bell, Associate Justices. May it please the court. My name is Ray Henson and I represent the appellant Jordan Manzi. May I reserve 1 minute for rebuttal?
You may.
Thank you. Summary judgment can only be granted when it is demonstrated that there are no issues of triable fact. In Manzi's case, there are issues of fact which warrant a jury trial. This court should reverse the Superior Court's order granting summary judgment for the following 2 reasons. First, Manzi's conversation within his private bedroom with a close acquaintance regarding sensitive health matters was a confidential communication under California Penal Code Section 632C. Secondly, Manzi's employer KEP intentionally recorded this confidential communication in violation of California Penal Code Section 632. Courts look at 4 different factors in determining whether a conversation could reasonably be considered confidential. These factors are the location where the conversation takes place, the subject matter of the conversation, the relationship of the parties to the conversation, and whether the parties knew that there were recording devices on the premises. Most significantly in Manzi's case is the location of this conversation, which was that of his private bedroom, which is a sacred and intimate location. In the case of Coulter versus Bank of America National Trust and Savings Association, decided by the 4th District Court of Appeals in 1994, the court held that conversations that took place within a private office were confidential. A bedroom is far more private and sacred than a private office, and as a matter of precedent, this court should protect the privacy of the bedroom from such violations of privacy.
Counsel, is it your argument that bedrooms are always confidential? What if you were having a party in a bedroom? And in this case, your opponent is arguing that the door was ajar and the housekeeper had just been there, and your client knew that voices could be overheard in the kitchen area. So being that confidentiality is an objective test, why is it that summary judgment was not properly granted on these grounds?
Yes, Your Honor. While bedrooms are not inherently private at all times, in this case, by virtue of Manzi's employment as a celebrity chef and a live-in chef for KEP, this bedroom was his only place of privacy within KEP's house, his place of employment. Comparable to that of the private office, this was his space where he worked, where he could go when he wanted a moment of privacy. He was assured that the bedroom would be private on the record at page 3. And further, the door remains slightly open, but Pritchard did attempt to close it when coming in for this conversation. And the door was only remained open because it had been damaged due to an earthquake, record at 23. And while the housekeeper had briefly been outside, Manzi instructed her to give him a minute and come back later, record at 25, emphasizing that he wanted his privacy for this conversation with Pritchard. Further, while he could hear audio from the kitchen at times, he did not feel the need to lower his voice during this conversation. As he stated on the record, "Why would we? We were in my bedroom." He felt that this was a safe place for him to have a confidential communication. And based on these factors, the jury should be allowed to hear the evidence and decide whether it was reasonable for him to believe this conversation was confidential.
So could we just go back one step? Because I'm a little bit concerned about whether this would be a close relationship when these two people really didn't seem to know each other all that well.
Yes, Your Honor. While they may have only met through Manzi's employer, Kep, over the months that Manzi worked for Kep, he had spent hours with Pritchard talking, laughing, and eating, record at 24 and 25. He referred to Pritchard as a great guy and one of the funniest guys he had ever met. Just throughout this time that they spent together, they were able to develop a relationship with a level of closeness that suggests that they could have a confidential communication. Further, their relationship had reached a level of closeness such that Pritchard even felt comfortable knocking on Manzi's bedroom door to have a conversation, record at 25. In the case of Wilkins versus NBC Incorporated, decided by this court in 1999, the court held that the conversation was not confidential because it was between virtual strangers. But here, Manzi and Pritchard were far from strangers because of this level of closeness that their relationship had developed through the extensive amount of time that they had spent together. Further, in the case of Frio versus Superior Court, decided by this court in 1988, the court held that close business associates could have confidential communications. Manzi and Pritchard here were not business associates per se, but they did have a relationship that reached a level of closeness such that a jury could find that it was reasonable for them to have a confidential communication based on this relationship of closeness and trust. Turning to the factor of the subject matter of the conversation, Manzi and Pritchard were discussing Pritchard's potential UTI, which is a sensitive health issue that many would feel embarrassed about talking about. Further, Manzi even shared his own personal experience with using this recommended supplement, Urinary X, disclosing his own personal health information and experiences, record at 26 and 27.
Counsel, can I ask you, how are we supposed to analyze the subject matter component of the test? Is it, because you're right, that particular snippet of the conversation you mentioned might be deemed confidential, but much of the rest of the conversation wasn't. So is it, if any portion of the conversation at all could be deemed confidential, we're supposed to treat the entirety of it as so?
Your Honor, if there is a sensitive component to the conversation where it is clear that the parties intended it to remain confidential, then yes, the conversation should be treated as confidential. In the case of Wilkins versus NBC Incorporated, the court held that a generic sales pitch which contained no secrets was not confidential because it was entirely generic and there was nothing secretive about it. Here, rather than being generic, this conversation was personal to both Manzi and Pritchard, and rather than containing no secrets, Manzi made the conscious choice to be discreet in his terminology by referring to the supplement Urinary X by the more discreet term of X, which he consciously chose because he knew the full name made some people uncomfortable, record at 26. This conscious choice that Manzi made showed that he wanted to keep this conversation sensitive and private. And as such, the jury could find that by virtue of the sensitive nature of this conversation, that it was reasonable for Manzi to expect that it would remain confidential between him and Pritchard. Turning to the factor of the knowledge of recording devices on the premises. Here, Manzi had no idea that there were cameras present. Even Kep admitted that he never disclosed to Manzi that there were cameras on the premises, record at 40. Unlike the case of People versus Nasri, decided by the 4th District Court of Appeals in 2010, where the employee specifically knew that there were cameras on the premises, Manzi had no idea that there were cameras there, and further had no reason to expect there would be cameras anywhere near his bedroom where they could record him. In the case of Santa Ana Police Officers Association versus City of Santa Ana, decided by the 4th District Court of Appeals in 2017, officers reasonably should have expected there to be hidden cameras based on both their employment as undercover police officers and the fact that they had already seen cameras previously, which they had disabled. Here, Manzi
But in your client's case, though, as I understand it, at every other private home in which he had worked, at least for celebrity clients like Mr. Kep, he knew that there were security cameras present. And so why was there any reason for him to think that there would be a different setup in this house?
Yes, Your Honor. While his past experiences had at other celebrity clients' houses did have security cameras, here at Kep's house, not only had he never specifically seen any, but he had no reason to expect that they would be anywhere near where they could record his bedroom. Even at his other clients' homes, Manzi emphasized that he never allowed his private living quarters or his private conversations to be under surveillance, record at 23, because his privacy was very important to him. He would not reasonably expect that cameras would be present in any vicinity where they could record him and his bedroom. His privacy was important to him, and because it was not reasonable for him to expect that recording devices would be present here, a reasonable jury could find that that this conversation was confidential.
Can I ask you? Go ahead.
I'm sorry, I'm concerned about the intentional requirement because it seems like there really was no intent to record this specific conversation. Could you address that?
Yes, Your Honor. In evaluating the intent to record, courts employ a dual definition of intent, which means that this court needs not find any evidence of Kep having malicious purpose behind recording Manzi, but merely that he knew to a substantial certainty that a confidential would be recorded due to his actions. And here, Kep was told by the We Protect You technicians when they installed the cameras that they could record audio from the bedroom that would later become Manzi's, record at 5 and 39. In the case of...
Yes, but let me just jump in. As I understand it, the test is not so much whether words might somehow be recorded, but rather whether a confidential communication would be recorded. And why wouldn't Mr. Kep just think that, well, if there were going to be a confidential communication occurring in the bedroom, the person would close the door and then my system wouldn't pick it up. So why was there any reason for him to think that there would be a confidential communication captured by the video camera system?
Yes, Your Honor. Firstly, Kep here knew that whether Kep knew that the door was broken and could not be closed would be a question of fact for the jury to hear and decide. And secondly, through his past experiences of listening to recordings, Kep heard on his recording system that he had in fact picked up audio from Manzi's bedroom. He recognized a word or two from what he believed was Manzi's room, record at 44. Furthermore,
Right, but my question is simply this: if a confidential communication were going to occur in the bedroom, right, and that's the only focus of the statute, wouldn't Mr. Kep be reasonable in assuming that the door would be closed such that the camera system would not capture the conversation?
Not necessarily, Your Honor, because during Kep's experience of listening to the recordings, he intentionally fast forwarded because he stated on the record at page 44 that he was not a peeping Tom, indicating that he knew there was something that he had recorded that he should not be peeping on, which could give him that substantially certain knowledge that he had recorded and could record confidential communications.
But counsel, if the recording is inadvertent, then it wouldn't be intentional, right? Because it seems like the goal wasn't to record this conversation.
Yes, Your Honor. The goal here was not to record this conversation, but in the case of Merrick versus MGM UA Telecom Incorporated, decided by this court in 2003, the court held that the knowledge that recording equipment being used was capable of recording the voices on the other end of the phone was sufficient to give the crew members that substantially certain knowledge that they would record the confidential communication. And here, Kep had heard audio from within Manzi's bedroom, which indicated to him that he was and could record confidential communications. This knowledge that his recording equipment was capable was sufficient to give him that substantially certain knowledge. Further, in the case of People versus Superior Court, also known as the Smith case, decided by the Supreme Court of California in 1969, the court held that recordings made by chance were not intentionally recorded. But here, Kep could not be recording by chance because he knew that he could record audio from within Manzi's bedroom. Whether or not Kep's knowledge that he was recording this audio was sufficient to give him that substantially certain knowledge is a question of fact that the jury should be allowed to decide. Furthermore, KEP's cameras were sound activated and would pick up and continue to record audio from within Manzi's bedroom, and KEP knew this. I ask that this court allow the jury to hear these facts and determine whether they believe that KEP's knowledge of the capabilities of his cameras was enough to give him that substantially certain knowledge that the courts require to show the intent to record. There is sufficient evidence both that Manzi's conversation was confidential and that KEP intentionally recorded it. So on behalf of Manzi, I ask this court to reverse the order granting summary judgment and allow the jury to hear the facts and allow the jury to decide. Thank you.
Thank you. All right, counsel for respondent, whenever you are ready.
Good afternoon, Chief Justice Bell, Associate Justices, and may it please the court. My name is Donald Bullock, and I represent the respondent in this case, Mr. KEP. Courts should be hesitant to label all conversations confidential. An individual who wishes to have a private conversation should take reasonable steps to ensure their conversation is actually confidential. Thus, this court should affirm the trial court's motion granting summary judgment because there are no tribal issues of material fact under California Penal Code Section 632A for the following two reasons. The communication between Manzi and Pritchard was not confidential, and second, KEP did not intend to record the conversation. Under California Penal Code Section 632C, a confidential communication means any communication carried on in the circumstances as may reasonably indicate that any party to the communication desires it to be confined to the parties thereto. To my first point, the conversation between Manzi and Pritchard was not confidential because based on the four factors the court will consider, the relationship of the parties, the subject matter of the conversation, the location of the communication, and knowledge of a recording device on the premises all indicate the communication was not confidential. To the first factor of confidentiality, the relationship between Manzi and Pritchard is one of acquaintances and not one of trust. As this court held in Wilkins versus National Broadcasting Company in 1999, when the parties were virtual strangers, that was not considered a relationship of trust. Here, Manzi and Pritchard were not considered virtual strangers, but record at 24 indicates that Manzi, when he was asked, was Pritchard his friend, he could not confirm that. He said he only knew him.
Counsel, I'm sorry, assuming that the relationship was close enough, I suppose my concern here is that the subject matter of this conversation is something that it seems like people would want to keep private. Could you address that?
Yes, Your Honor. As this court held in Wilkins as well, is that when there was a commonly recited sales pitch given to other people that contained no secrets, that was not considered confidential. And here, record at 26 indicates that Manzi had professional knowledge about this. He talked about health supplements all the time. Manzi even stated he was actually pretty annoying about it. Additionally, the record indicates that at 26 and 27, that there was no difference between what Manzi would tell Pritchard than versus his other former clients.
But we have to look at both people involved in the conversation, correct? So if Mr. Pritchard was approaching Mr. Manzi to talk about his urinary tract infection, it seems like that would be something Mr. Pritchard might not want the whole world to know.
Your Honor, here we are looking at whether one party reasonably expected whether the conversation would be confined to the parties there too, and Manzi is the one who filed suit here, not Pritchard. So we are looking to Manzi's intent to, or excuse me, not Manzi's intent, but Manzi's expectation that the subject matter was actually private. Additionally, speaking on the topic of the subject matter, Manzi even noted that he was talking about a herbal supplement, record at 28. And referred to the name X or UX, which is a common name that people knew about in terms of the herbal supplement, which indicates that this supplement that Manzi was recommending for symptoms that were consistent with a urinary tract infection was actually more public than it was considered private. Moving on to the location factor of confidentiality. Manzi's negligence in ensuring the location remains private, so this is not a private location. A communication that takes place in a location or setting that one can be easily overheard may not be considered confidential. Once again, citing Wilkins, where the parties were outdoors and were speaking about a common sales pitch, they could not reasonably expect that the location was confidential. Here, record at 25 indicates that Manzi recognized that the door was open, but yet he failed to close it. Additionally, record at 25 indicates that Manzi asked the housekeeper to wait 1 minute outside, but yet he never actually ensured that the housekeeper was gone. Mancy's negligence, or at least carelessness, in ensuring the location actually remained private indicates that the location could not reasonably be considered confidential. Additionally, once citing Mesner versus Bick, where this court held in 2021 that where the parties are speaking at elevated volumes, they could not reasonably expect that their conversation could be considered confidential. Here, record at 26 indicates that Mancy did not lower his voice during the time of the conversation. He stated that why would he? So the fact that Mancy never once lowered his voice during the time of the conversation, despite failing to check if the housekeeper was outside and noticing that the door was open, all indicates that Mancy did not take reasonable steps to ensure that the location was actually considered private.
Counsel, can I get clarification on one point? You've said several times that the door was open. My understanding is that it was just kind of a little bit ajar because it couldn't close it couldn't close all the way without some effort. I think I would understand your argument better if the door were just left wide open, but my understanding is that that's not what happened here.
Your Honor, here as the record indicates, before the conversation took place when Pritchard went to knock on the door was actually closed completely shut. And as Pritchard came into the room, the door was not closed all the way, albeit that it did require a little bit of effort. Mancy noticed that the door was still open. The door was capable of being shut, despite the fact that it required a little bit of effort, which the record indicates. So the fact that the door was still open, although we don't know the degree, indicates that they reasonably could not expect this conversation would be considered confidential. Additionally, record at 24 indicates that Mancy shared a wall with the kitchen, and he's also heard sounds coming from the kitchen before, which would indicate that Mancy cannot reasonably expect that people could not hear his conversation, especially when they were speaking at an elevated volume, and they did not take reasonable steps to ensure that the door was actually closed.
Counsel,
Go ahead.
please proceed, Madam Chief Justice.
Thank you. So, counsel, does the record reflect that their voices were elevated or just that they were not speaking in, say, a whisper or a low tone?
Your Honor, a clarification point, they did not lower their voices during the time of the conversation. But as the conversation started, they were actually speaking, they were laughing and joking around, which indicates this might not have been considered a lower volume of tone.
Okay, thank you.
Additionally, moving on to the fourth factor of confidentiality, Mancy knew or should have known that his conversation with Pritchard would be recorded because based on his experiences living with celebrities who also contained indoor surveillance.
Counsel, along those lines, on that issue, you keep raising the negligence of Mr. Mancy for not completely closing the door. Does the record reflect whether your client told him that there were recording devices in the house?
Your Honor, the record does not indicate that he knew that my client told him that there were recording devices inside the house, but as record at 23 and 24 indicates that Mancy knew that celebrities liked their privacy because it was important to them. And record at 21 indicates that Mancy had been a celebrity chef for over 13 years, where many of the people that he lived with and worked for had cameras inside of the home at that point in time, which indicates that Mancy should have had at least some form of knowledge that there could have been cameras inside of the home at that point in time while he was living with Kev.
Does the record reflect whether all of those cameras also had audio recording devices?
Your Honor, no, the record does not reflect that all the cameras had audio recording devices, but the record does reflect that many of them did have cameras and doors inside of their homes, and Mancy has had previous experience with this, which indicates that he reasonably should have known that there was cameras on the premises. And citing where the law drew a clear line in Santa Ana Police Officers Association versus City of Santa Ana, where the 4th Appellate District held in 2017, that while the police officers were conducting a drug raid, and when they reasonably should have known that there could have still been cameras on the premises at the point in time of the conversation, which then in turn leads me into my second point. Pep did not intentionally record the conversation because he didn't have the purpose or knowledge to be substantial certainty that his cameras would result in the recordation of a confidential communication. As the California Supreme Court held in People versus Superior Court, also known as Smith, recording a confidential communication means so if you do so intentionally with the purpose or desire to record a confidential communication or of knowledge to a substantial certainty that his use of the equipment will result in a recording device. Kep did not have the purpose to intentionally record the conversation because it was made by chance. As the California Supreme Court held in Smith, recording a communication by chance does not indicate one's purposeful intent to record the conversation. Record at 39 indicates that Kep only heard a couple of muffled words that were coming from the bedroom. A couple of muffled words does not rise to a level of substantial certainty. That's merely conjecture. It's merely conjecture. Kep was not 100% sure that this actually even came from Mancy's bedroom, let alone it from down the hallway or not, which indicates that Kep could not have had.
I'm sorry, counsel. I just have some concerns about that because the record reflects that the installers of the security system informed Mr. Kopp that conversations from the bedroom could be overheard, depending on whether the door was closed more or less. And then on top of that, Mr. Kopp had listened to a recording before where it was apparent that at least some words could be heard. So it seems like he knew that this was a possibility.
Your Honor, the key word inside your question, as we protect you, told Kep, as the record indicates, is it could catch actual words. There was nothing that was substantially certain that would actually capture the words or capture a conversation inside of Mancy's bedroom. Additionally, as Kep went back to review the footage in July of 2022, he only heard a couple of muffled words or sound, and he was not sure where that was coming from, which could not amount to Kep knowing that actually came from Mancy's bedroom if he was not sure. He said that he did not know. Additionally, Kep did not have knowledge to substantial certainty that his cameras would record because, as the record at 43 indicates, that he only had one prior experience working with the cameras at this point in time, which was the July of 2022 date, as you asked about, Chief Justice. And as the law drew a line in Marriage versus MGM Telecommunications, where substantial certainty is when the party who was a highly experienced sound technician knew that it was recording sounds on the other end. Kep is not a highly experienced sound technician inside of this instance. Kep has had one instance where he merely could have heard sounds that have come from the other line. That does not amount to substantial certainty. Additionally, citing Lozano versus City of Los Angeles, where the second appellate district, where this court held in 2022, the plaintiffs failed to establish who intended to activate the system to record the conversation. And here, we don't know that Kep actually intended to activate the system on that day in question on August 5th. And on the day in question,
if I can just go back to the point that the Chief Justice made, when your client is told by the technicians who are installing the system that it will be able to pick up actual words if the door to the bedroom is open, it seems to me that just puts your client in a different posture because he's allowing the system to continue running every day, presumably. And so in the event that a confidential conversation occurred in the bedroom with the door open or at least partly open, it seems to me he did have substantial certainty that actual words were going to be recorded and audible when he went to review them.
Your Honor, here, this really just amounts to by chance. There was nothing certain that on the day in question on August 5th, that Mancy was going to be having a private conversation inside of his bedroom with Pritchard. Kep could have not accounted for that. Additionally, this once begs again the question of personal responsibility. Mancy's personal responsibility in ensuring when he was a guest inside of someone else's home to ensure that his conversation actually remained confidential. Mancy did not close the door as he noticed the door was open.
Counsel, is this a comparative negligence statute? You keep talking about personal responsibility. And as I indicated, if we want to talk about negligence types of standards, your client did not tell Mr. Mancy that there were audio recording devices in this house that could pick up sounds from the bedroom. So how does that play in your argument?
Your Honor, no, this is not a comparative negligence statute, but additionally to your question is that Kep informing Mancy of the cameras was not an absolute duty. It would have been a courtesy for Kep to inform him of the cameras, as Mancy should have had knowledge that there were cameras on the premises, as he has been a celebrity chef for over 13 years, where there's been previous cameras inside of the home that he's lived in. And the fact that he knew that celebrities like their privacy, all indicates that Manzi also should have known that there would have been cameras on the premises, and the fact that Kep happened to stumble upon it by chance does not indicate that Kep knew to a substantial certainty that the cameras will result in the recordation of a private conversation. Policy would best serve that this court upholds the motion for summary judgment. While privacy is expected for every citizen, personal responsibility is also at the crux of ensuring a conversation is confidential. For these reasons, this court should affirm the motion for summary judgment because there are no trial issues of material fact. Thank you.
Thank you. Rebuttal?
Your Honors, I have one brief point for rebuttal. Opposing counsel opposes that in order to have a reasonable expectation of privacy, Manzi should have taken steps such as closing his door, ensuring the housekeeper had actually left, and lowering his voice. However, in Manzi's mind, it was reasonable for him to expect privacy because he was within his bedroom. He had told the housekeeper to leave, and the door was mostly closed. Whether or not additional steps must be taken for him to ensure his privacy is a question of fact that should be left to the jury for them to decide. Thank you.
Thank you.
Congratulations, competitors, on a wonderful round. At this point in time, we'll be having the competitors move to the competitor room while the judges move to the judges room to deliberate. So if you're watching from home, please bear with us while we take a moment to let the judges deliberate. Competitors, if you go to the bottom of your screen, that should be a breakout room section. If you could select competitors room. And then judges, likewise, if you could select the judges room, and I will meet you in there.
Okay, I'm not seeing an option to select the judges room.
Be more difficult on your iPad. Let me see if I can move you. Julia, do you have the power to, you got the power here?
Yes, I'm going to move you to the scoring room and then to the judges room.
Okay, very good.
You're gonna hop around for a minute. I'll meet you in
Okay,
there.
great.
Justice Watford, you should have gotten a notification to move to the breakout room.
I'm just not seeing any notification. Like where I could click on it. No.
Judge Watford, do you see at the bottom of your, I don't know, kind of a computer you're on, navigation, do you see the word breakout rooms? At the very
No.
bottom of your screen? Ah, okay.
No, I don't see anything at all. Oh, wait a minute. Let's see. Okay, maybe now. Let's see.
Okay. Good. All right.
You're muted, Claire.
I think we are ready to move the competitors back and announce or move everyone back, in fact.
All right.
We'll give everyone a moment to come back. Justice Bell, whenever you're ready, if you'd like to say a few words.
Sure. First, congratulations, Donald and Ray. You both did just an outstanding job. You were far more prepared and did such a nice job citing the record. I'm much better than many attorneys that appear in front of my court. So you both really should be commended. You knew the problem backwards and forwards. You knew the record. You knew the cases. You both did an excellent job of weaving in the facts in the record and the cases into your argument. I would say watch out for verbal tics. Ray, there were a few ums and a as I just watch out for that. This is a very nitpicky things because I really thought you did such a fine job, and I would say Donald especially, but also Little Ray, slow down a little bit. It's so hard, right? You have I was an appellate lawyer many years ago before I became a judge, and you have like this limited time and you want to get everything in, but if you talk too fast, the judges or justices won't hear you. So you're not going to get everything in, and that's okay. That's part of the exercise, but just slow down a little bit. You have to be really conscious about it, because I know when you're a little bit nervous too, or at least when I'm a little nervous, I talk really fast. So just slow down a little bit. It's okay. If you get a question, it's okay to have silence for a few seconds while you think about the answer. Nobody's going to hold that against you. Don't feel like you have to fill every second. Sometimes it's nice for judges to have a few seconds just of quiet to also kind of go through their thoughts. So, take your time, take a second, answer the question. Don't feel like you have to, fill the void. And I mean, with that, I thought those were my main things. So, Justice McKenna?
Yes, both of you, Donald and Ray, you were both excellent. Just amazing, as Justice Bell has said. I wish that all counsel that appeared in front of us had your composure and style and, oratory skills. Both of you are excellent. I know that you're both going to be great lawyers. I would echo that it's a little difficult, especially when you get a little bit older like myself, to follow speech that is that fast. And I was guilty of that myself as a young lawyer. I'll never forget one of the first major oral arguments that I went into a hearing in a trial court. And I just remember, it was a motion, I think it was a motion for summary judgment. We're just arguing back and forth. And as you're talking, you start talking faster and faster, right? If you know this stuff. But we're trying to process what you're saying. But I'll never forget that the court reporter, this is back when I don't know how courts are now, but we still have court reporters that take down the stenography. She threw up her hand and she said, "Slow down." I learned my lesson. So it is important to speak a little bit more slowly so that the judges can process what you're saying. And please just respond to the questions. And I would say that there were basically 5 points that you could make here. The 4 factors of confidentiality, and then the intentionality, the substantial certainty. In a 15-minute argument, as a practical matter, you may want to focus on your 2 to 3 strongest points and maybe concede. When we get to oral argument, we know which points the attorneys really think are their strongest points, because it may have been, some points may have been in their brief, but they don't really argue them because they're not as strong, right? So, in that view, I thought, I'm going to be totally honest, I thought that the facts and the law were so much stronger for the appellant here. Candidly, I did not see this as a summary judgment case. So I thought that the respondent had a really, really tough argument. But so, I would say that perhaps for the respondent, maybe just pick a few points and, try to make some policy arguments as to why your client should prevail in a situation like this. But anyway, both of you were really, really good, and congratulations.
Yeah, well, I can only echo the praise that my colleagues have already offered to both of you. I really would compliment you on your skill as advocates. One of your professors reminded us before we came on that you guys are just a year into your legal education. It's really pretty stunning because we often see lawyers who are not as skilled as both of you are, been practicing for many years. So both of you have just extraordinarily promising careers ahead. I don't have any kind of constructive criticism to offer either of you beyond what my colleagues have already indicated. So maybe I can just indicate a couple of points of praise. I thought for both of you, the command you had of the record and the ability not only to have all of the pretty fine-grained details of the factual record at your fingertips, but also to be able to give us record sites as to where we could find them was incredibly impressive. I am, and that's critical, obviously, in a summary judgment case. I am amazed at how many times on appeal, in a summary judgment appeal, which is just by definition, you got to be steeped in the factual details of the record. We ask a question of counsel and they're not that familiar with the details, or we ask, well, where can we find something? And they can't tell us. And both of you just really honed in on that and we're ready to go. Same thing in terms of your ability to marshal what you could from the case law that's out there. Again, I thought both of you did an excellent job in drawing on the cases that favored you, because there were some cases that favored the respondent, some cases that favored the appellant, and both of you had a real good grasp of which were your best cases, and you were able to lay out for us what were the helpful holdings in those. So just the command of the record and the case law was really above and beyond what I would say the average level of advocacy that I see, at least in my court. You also both did a terrific job of stopping when you were getting questions. Oftentimes the inclination is just to keep talking and not want to be interrupted, but you were both very responsive to the questions that we posed. And I think for both of you, one of the hard things about getting interrupted, especially when you feel like you're in the flow of making a point, is to be able to take a question and pivot to a strong point for you, right? You obviously, if you're getting a question, or especially if we framed it in terms of, well, counsel, I'm concerned about this, or I have issues with that, you want to be able to address the concern head on, but also try to pivot the judge back to a point that's strong for you. And again, I thought both of you did a terrific job on that front as well. So I was really impressed. We were told ahead of time that we were in for a treat, and neither of you disappointed. It was really just a terrific argument on both sides.
Fair.
Chief Justice Bell, would you like to do the honors as our Chief Justice for the day?
I would, and I do want to see that in our consideration, I think we all felt that the problem, I think it was a really good problem, and they're supposed to be close, you know, it weighed a little towards the appellant side, and we didn't consider that in our decision. So the winner is Ray Henson. Excellent, congratulations.
Yay! Congratulations, Ray. And congratulations, Donald. What a phenomenal
Yes.
round. You should both be extraordinarily proud. We're all very proud of you. Thank you to our amazing panel of judges, to both of our competitors for a phenomenal round. You know, this one's for the books, definitely. To our co-directors, Professors Carpenter and Jatalia, thank you both. And on behalf of the Moot Court Honors Program Board of Governors, we just want to thank everyone at home for watching and all of our competitors for making this such a phenomenal intramural competition. It was such a treat to have you all join us. So thank you, everyone. And Stephen,
Right.
you stop the live stream.
Truly an honor.